talking to the IT team, the claims team, and we look forward to a very, very interesting session. If you guys have questions, once again, please just pop it into the chat box on Teams as well. Just pop your question into the chat box. We'll make sure it gets dealt with in the Zoom meeting. And yes, over to you, Stefan.
Thank you very much, Tammy. Yeah, there was just a whole host of things going on in the background here, you know, the production team and the makeup and everything. They said I must put on my hat for today because it's too shiny and all of the lights and the production lights over here. So yeah, so thank you very much for this opportunity. It's an awesome opportunity. I know you guys pride yourself on these sessions, so I do hope that I'll be able, and I do trust that I will be able to make a contribution today. My previous session on doing something like this was to talk about some interesting, you know, cases that I've dealt with over the, you know, the last 20 odd years. That is obviously very exciting on the one hand, talking about notification and load notification and events that gives rise to what we refer to as a notifiable event. Obviously trumps that insofar as that being an important issue for today and specifically for the clients and the brokers' clients and things like that. So, but I'll also try and make it as exciting as I possibly can. All right, so good morning to all of you. Thank you for making the time to spend the next half an hour. Actually, timed myself. I think it's probably going to be only about 25 minutes. So there's going to be a time for questions and things like that. So yeah, so thank you for this half an hour or so that we're going to be spending together today. To any of those potential, I'm not saying that there is any or possible attendees who was told to attend this meeting, enjoy your music or whatever you're going to be doing for the next half an hour. You will be happy to know, like I said, that I will be brief. Okay, so I will start this session with one of the great existential questions of all time. And that is obviously, who am I? All right, so my wife is into psychology and we often talk about that. So who am I? So my name is Stefan de Swart, as you've probably heard by now. I am an attorney. I'm based in Cape Town. We do work across the country. My firm is called Mallows and de Swart. We specialize almost exclusively in litigation on behalf of insurers and brokers such as yourself. I say almost exclusively because you do have the odd family member or a friend who wants something done for them, obviously for free, and then we do get involved in all kinds of stuff, anything you can imagine under the sun. But anyway, except for that, we mostly do insurance work. Yeah, so you would have been, not yet. I can provide you with a short bio of myself. Anyway, you can probably get that from I2 afterwards if you want to. Maybe just a couple of you know, highlights from our firm, which is going to be about 2 minutes. Our firm started back in 1995. Interesting story about how we started is that the firm was started by a lady called Susan Mallows. She worked at a couple of the big firms. She was at a particular firm at the time, you know, one of the big five. I won't name any names. And she was requested by one of her insurer clients whether she would actually be interested in going onto her own. The proviso was obviously, you know, that she's only allowed to charge 1/3 of her current charge out rate. And that, ladies and gentlemen, is how our firm started. Okay, so that's almost, can't believe it, 30 years ago. COVID and all, you know, we're still busy. We're still going strong. And it's a real blessing. You know, just from my side, on a personal note, I love my job. I love the field of insurance. I find it interesting. I get to sometimes, you know, I get involved with anything under the sun. It feels sometimes, you know, sometimes I get to be a cardiologist. Sometimes I'm a winemaker. Sometimes I'm an attorney that's in trouble, you know. So yeah, so that's interesting, and I absolutely love my job. But just to get back to to you as well as, and you, the audience, you know, to help people is obviously rewarding in itself. But I see us as a group as problem solvers. You know, problem solvers for both our clients and our insureds, and fortunately also we obviously get paid to do that. However, when it comes to the insured client, and you know, I don't know how many of them are actually taking part in this particular session, but probably most of you are brokers, are insurers, etc. You know, we all need to fulfill the role of parent sometimes, guardian, you know, psychologist, financial advisor, legal advisor. You know, I mentioned financial advisor, but that's fortunately only in the worst case scenarios where there's a limit of indemnity and you need to assist this guy. So, you know, as far as we are able, we help people that is in trouble or does have a particular problem. Okay, so that is really our focus. That is really what we want to do at the end of the day. And obviously crucial to that is also to make money, to be able and to be viable at the end of the day in doing all of that. Okay, so balancing everything that I've just mentioned to you, to get back to my existential question I asked right at the beginning as to who am I would like to include all of you in answering basically that I believe we are all problem solvers, here to help make a positive difference in people's life, making some money whilst doing it, and to do all of that in the world of insurance. And then to get basically to our topic for today, I believe requires us to be fair, to be able to put yourself in the shoes of the insured client, the shoes of the broker, the shoes of the insurer, to then be in a position at the end of the day to make an objective decision and to be objective in all of our dealings. And, you know, not forgetting, like Nadia always say, I actually borrowed this from her, you know, that not forgetting that we all want to sleep at night. So anyway, having said that, you know, giving you sort of like a short introduction to who I am. I know as I'm going to be going through the presentation that there probably will be some questions, but I also know that some of those questions will hopefully be answered, you know, as we go along. So if it's all good and well, because it's not that long, if I may suggest then that we keep our questions to the end of my short presentation, and then hopefully the panel and myself, we can obviously give you answers or some guidance with reference to the questions that you are asking. All right, so the very exciting topic for today, some of you is going to find it like Insurance 101, but it does get complicated every now and again. So let's talk about notification of circumstances which may give rise to a claim. Okay, so what is our immediate concern when we hear the word notification or circumstances, you know, notification of circumstances which may give rise to a claim? Okay, so the answer, it's obviously there on the slide. As far as an attorney is concerned, I'm concerned about repudiation. I'm concerned about there's not going to be cover for that particular event because the event was not notified. Okay, so this is a very important topic for brokers, a very important topic for specifically the insured client. So where do we start when we consider whether an event is notifiable? Okay, whether it is a notifiable incident. Okay, and to do that, you know, there is no one size fits all. We need to have a look at the insurance contract. Okay, so we need to look at the interpretation of the specific clause dealing with notification in the insurance contract. Okay, like a colleague of mine once said, you know, by now we know that a contract or policy means what the court says it means. Okay, so we're basically writing our policy, attorneys write our letters, etc., in order to be eventually perhaps evaluated by a judge. And the judge will give us basically the meaning. So it's therefore very important to look at how judges, how a court, if there's going to be a dispute, or the ombudsman is going to be interpreting the insurance contract. Okay, and what are those rules followed in South Africa? Okay, so just carry on. So you'll see there on the screen, I've set out 4 rules of interpretation. There's actually 8, 9, 10, there's a couple of them, but I believe this particular 4, these 4, there's actually another 2 that I'll talk to you about just now. But these 4 are the most important. And I think the very first one is probably the most important. Okay, so in the first instance, making a reference to language used, words must be given their plain, ordinary, and popular meaning, unless the context indicates otherwise. So if it says Yanni was bouncing his red ball across the street, then that's basically what it says. It's Yanni, that we know who it is, or whatever. So yeah, just plain, the plain meaning of the language. Okay. The second one is provisions which purport to limit a clearly expressed obligation to indemnify. Okay. So if there's an exclusion or whatever, okay, those exclusions, etc., will be restrictively interpreted. Okay. So it's not going to be, unless the wording says it covers a specific aspect, then if it's unclear, it's going to go against the insurer. All right, so the third one, it is the insurer's duty to make it clear the extent to which an insurer's liability is limited, i.e. what is a notifiable event must be plainly spelled out. Okay, so that's why when it comes to these things, first and foremost, grab the insurance contract. Have a look and see where it deals with what is a notifiable event, and have a look at that, because that's, as far as I'm concerned, the most important thing to do. All right, and then the fourth one, in the event of ambiguity, the contract is construed against the party preparing it. Now, you've heard this 1,000 times, no doubt. We are talking there about the contra preferentum rule. Okay, so there are others. I'm not going to bore you with them. They've got these big Latin names, etc. But I think the 2 that I do want to refer you to is the second last one on the slide. It is for the insured or the reinsured or the underwriter, whatever, to prove that an event falls within the, it is for the insured to prove that an event falls for the insured to prove the application of an exception upon which it relies. So once again, we actually dealt with it previously. As soon as the insurer wants to limit its exposure or limit its indemnity, it wants to provide to the insurer with reference to a specific clause, with reference to an exclusion, then in those circumstances, the onus is on the insurer. Okay, so now we've looked basically first and foremost at what is important when it comes to events and determining whether that event is notifiable or not. So what I've explained to you thus far is we need to look at the insurance contract. We need to look at the definition of what is required of the insured in certain circumstances, the circumstances under which the insurer will expect the insured to notify the claim. Okay, and we've now looked at some of the rules of general interpretation as to how we go about interpreting those clauses in the insurance contract. All right, so hopefully that is as clear as, hopefully not mud, but hopefully that's clear so far. Okay, so now we're going to get to the boring side. Okay, but it's only going to be the following 2 slides, and I'm quickly going to go through it, but I have to read this to you because I really believe this is, the Mount Everest of when it comes to late notification. That is the section dealt about, with what is a notifiable event in LAWSA. And then we're also going to be looking at a very familiar case to attorneys that we consider just to determine and advise our clients as to whether a specific event was or was not notifiable. Okay, so let's just start with LAWSA quickly. All right, so liability policies as a rule require the insured to notify the insurer of particular events that may give rise to a claim. Okay, as a rule, you're going to find this in probably 100% of policies, okay? The purpose of the notification is to alert. This is the purpose. Purpose of the notification is to alert the insurer to the possibility of an action so that they, the insurer, okay, may take steps to mitigate the insured's loss or liability, and with it, their liability to pay him an indemnity for it. A problem we often find is that we get involved right at the end of the particular matter. This thing has been going on for a year or 18 months or whatever. And if we were involved right from the beginning, if legal advisors such as Nadia, Carmody, Marlon was involved right at the beginning, things could have been, dealt with, could have been steered in a specific direction. And now we obviously sometimes, not always, but sometimes we sit with a matzah pudding, that we now have to sort of like sort out, which is way too late. Okay, so under an occurrence-based policy, a claims-made policy, for instance, the insured will be required to notify the insurer of any occurrence that may give rise to a claim. All right, any occurrence. Notice is to be given of an occurrence giving rise to a claim against the insurer, not, listen to this, of a claim by a third party against the insured. Having discussed this with a couple of people and also with Nadia and the team yesterday, one of the main reasons what I find, having thought about it, as to why the insured do not notify insurers is that they think, well, you know what, this guy is now, he's miffed, there's a problem, okay, but you know what, this is not the first one this month, okay? So what we'll probably do is that only once he receives a letter of demand, or, there's some sort of a real threat or a summons, he think that will justify as being defined as a notifiable event. And that is not the case, okay? It's not the case. The case is, as they say in the following actually slide, the insured cannot wait for a third-party claim against it before notifying the insurer of the occurrence having taken place, as the duty of notification is not dependent on a third-party claim arising from the occurrence having been made against the insured. Okay, so that is unfortunately one of the main reasons I sometimes think our insured clients do not report a matter. They think, no, there's no letter of demand, there was no approach from a third party, there was no threat of a claim. That is not the definition or the requirement in our policy agreements. Okay, so let's then look at LAWSA 12.1, second edition, paragraph 380. Okay, so there it says, and I would like to also highlight this to you, a term requiring the insured to notify the insurer of the occurrence of an event is generally construed as a vital term to the policy contract. Okay, that's a vital term. Even in the absence of words empowering the insurer expressly to refuse a claim on breach of the term. Okay, the term is regarded as a condition precedent to cover. So accordingly, where the insured has failed to give notice within the time specified, and if no time has been specified even, within a reasonable time, the insurer is entitled to refuse the claim, irrespective of whether the insurer has suffered any actual prejudice as a result. So strict compliance will be required, and any non-compliance, whether because of ignorance or impossibility however reasonable. This guy could have been run over by a car the following week. He could have been in a coma. Nobody knew about it. Unless the insurer is going to feel sympathetic towards the insured. An insurer is legally in a position, okay, to say to the insured, you are in breach of a vital term, and consequently, we are entitled to repudiate. And I believe case law and our legal principles that I've just highlighted to you will back that up. So this is why this whole issue of notification is so important. Okay. Now, probably some of you are getting worried about this particular aspect, but let's just have a look at how our courts applied it in a particular matter. You may have or may have not have heard about this particular matter. It's the matter of Thompson versus Federated Timbers. Before I'm going to go there, I just wanted to just tell you quickly about the matter. All right, so what happened here is it's a classic slip and fall. Okay, we've all dealt with those sometime or another. I started doing slip and falls when I was a young attorney. So what happened here was on the 18th of March 2018, Mr. Thompson, as we all do, go shopping. So we went shopping at Federated Timbers. He was walking down the aisles, and the next moment he fell. Okay, and I can just imagine him looking down, see what on earth happened just now. I'm in pain. And he looks down and he finds the electrical cord on the floor. All right, so Mr. Thompson is obviously not very happy. Case law says he would be looking at the shelves. He would not necessarily look down at the floor, so he has a very good case. Okay, so Mr. Thompson, what does he do? What does most plaintiff attorneys do? They go and sue Federated Timbers. All right, so summons is issued, Federated Timbers plea, and then 6 months after the plea, the attorneys for Mr. Thompson directs a letter to the cleaning company. Okay, so now, first and foremost, the cleaning company probably knew about this particular claim on the day, because you can imagine who that particular electrical cord belongs to. It's probably some other buffing machine that this particular cleaning company was using at the time. Anyway, so there already, one could probably argue that it was a notifiable event. But then what happens is 6 months after Federated Timbers filed their plea, pointing fingers, no doubt, at the cleaning company and or using that as an excuse to defend the matter, saying, listen, we've complied with our duty of care. Okay, we appointed a cleaning company. Okay, the cleaning company is an independent, entity, and they should accept liability for the wrongful actions of their own employees. I haven't read the plea, but I can just imagine it's something along those lines. All right, so now there's some queries directed at the cleaning company by the plaintiff 6 months after the plea. And they say to them, listen, guys, we want to know X, Y, and Z, probably what was your cleaning schedule, et cetera, et cetera. But then in the same breath, okay, they also say, listen, with reference to the defense of Federated Timbers, we may have to join you guys to this particular action. So they tell them in that letter. Okay, all right, so nothing happens. The queries are answered by the cleaning company, one of their managers. Okay, nothing happens. And then in December of 2009, if I remember correctly, now the incident happened in March 2008, December 2009, all right. What the plaintiff does is he could have either, issued a third-party notice, or in this particular instance, he issued a summons against the cleaning company, and the cleaning company enters an appearance to defend. And this particular cleaning company was insured with Zurich. Okay, and so Zurich obviously looks at this particular matter, and then they obviously appoint loss adjusters or attorney like myself. They investigate this particular matter, and they get back an opinion or a report. Okay, so having said that, let's just then look at this particular slide, because there's a lot going on this slide. So as far as I'm concerned, we have a fairly simple set of facts. So I see there, sorry, I've got it wrong, my dates. It was in June 2007 that the incident happened. Okay, so he issued summons, Federated Timbers filed a plea. There was that letter that I told you guys about 6 months after the plea, asking certain specific questions, advising them that they may be joined. Okay, and then there is the summons in December of 2009, all right? And the insured obviously then, okay, well, sorry. The Zurich investigates the claim, they get an investigation report, and more specifically, a set of facts. Okay, so very important now is to remember, we started off by saying, what is a notifiable event? We need to look at the insurance contract, okay? Then we need to look at how courts interpret that insurance contract. Now we have, by using this illustration, we need to get a set of facts, okay? So now, using this case, we put ourselves in the shoes of Zurich, okay? So now we have the facts. What do we do? Okay, we go and look at the policy agreement. Okay, so what does the policy agreement say? Okay, dealt with all of that. There we go. The policy agreement in the general exceptions, conditions, and provisions of the policy reads as follows. Okay, A, now let's look. On the happening of any event which may result in a claim under this policy, the insured shall, at their own expense, 1, give notice thereof to the company, who is now Zurich, or their brokers, as soon as reasonably possible, and provide particulars of any other insurance cover such events as are hereby insured. Okay, so that's not really relevant. Probably there was no other insurance. Anyway, so they need to give notice to the company. Okay, 2 is not that important. 3, as soon as practicable after the event, submit to the company full details in writing of any claim. 4, give the company such proof, information, and sworn declaration as the company may require, and forward to the company immediately any notice of claim or any communication, writ, summons, or other legal process issued as commenced against the insured in connection with the event giving rise to the claim. All right, so just looking at that, okay, and I'll give you all the reasons why just now. Zurich rejected the claim, okay, alleging, and I refer to them as Durban Cleaning or the cleaning company, okay. So they decided to reject the claim, alleging that Durban Cleaning failed to comply with the notification provisions of the policy. Okay, so the relevant issue to be decided was thus, at what stage it was reasonably possible for Durban Cleaning to have notified Zurich of the event. Okay, so we've got our agreement, we've got our facts, okay. We know that there's going to be an investigation, putting yourself maybe in the shoes of a broker. Okay, so there's an investigation, Zurich get a set of facts, and now they've repudiated. Okay, now obviously the insured is unhappy. Okay, so what does the insured do? He joins Zurich to the action, okay, as a third party. Okay, why? Because he wants indemnity from Zurich. Okay, now our esteemed Judge Wallace, okay, he was obviously presiding over this matter. They decided that this was a particular point that needs to be decided before they go into the rest of the court case. Okay, and he actually assists us by going and going back to what he refers to as the test for reasonableness. And now this is very, very important. I want you to remember this: the test for reasonableness, or then the reasonable insured. Okay, so everybody made their arguments, and then the court held the following. Okay, court held that the requirement that the notification be made so soon as reasonably possible must be seen as soon as is reasonably practicable in all circumstances, in all the circumstances. So they probably just looked at the wording applied those interpretations that I've referred to. It's fairly simple, it's clear, okay, and this is the answer, okay. So, and he says, the inquiry is a factual one, okay, that's fairly easy. And the answer will depend on the circumstances of each particular case, all right. Now, by now we know you can't extrapolate the facts of one case to another, etc. Okay, so that just not happen. So we need to look at the circumstances of each particular case. All to say, basically, when it comes to what constitutes a notifiable event, there is no one size fits all or a universal formula to be applied. All right, so this I will maybe later, but maybe now, but I'll give you I'll just explain that slightly better. But you know, just remember, there is no one size fits all, and this is what our judge said in this particular instance. All right, so to assist us in doing so, the court held, okay, to find out what is reasonable, what is not, you know, what is the relevant conditions that apply. To assist us in doing so, the court held that while the test of reasonableness is an objective one, okay, it highlighted the necessity to also consider certain objective elements, and I'll explain that as well. The court held that two issues potentially arise as to whether in fact there was an appreciation of the possibility of a claim being made under the insurance policy or not. Okay, so now that's another word I want you to remember. The first one is reasonable, and the second one is an appreciation. Okay, so A, if there was such an appreciation, so the insured, the event took place, he thought, oh, damn it, this could lead to a potential claim. There was such an appreciation, and that is the end of the matter. Okay, so either the insured will tell you as much, oh, geez, I knew this was going to be a problem, or there's some correspondence or emails going back and forth to his boss saying, oh, you know, this is a problem. Okay, so if there was an appreciation, that's the end of the matter. The claim should have been notified, i.e., in the mind of the insured, this event could potentially lead to a claim. Okay, so that is obviously the obligation to notify the insurer of the relevant event is then clear. Okay, if, however, the court is not satisfied that there was such an appreciation, all right, so he heard the evidence of the cleaning lady or the whatever the manager was, the area manager of that particular time. He heard the evidence from the area manager, and it's clear to him that, you know what, she didn't appreciate that this could potentially lead to a claim. The court said that does not resolve the issue the other way. Okay, if the failure to appreciate the possibility of a claim is unreasonable, all right, in the sense that a reasonable insured in the same position would appreciate the possibility of a claim. The fact that the particular insured did not appreciate the possibility of a claim cannot relieve it of the consequences of its failure to notify the insurer of the event. Okay, so to go back to my slide, okay, so there you'll see I said translation of what I've just all said. And I tried to dump it, you know, just to make it easier for myself. Okay, so first and foremost, it's easy. There was a clear and evident appreciation of the possibility of a claim. B, the reasonable insured in the same position would appreciate the possibility of a claim, whereas the actual insured did not, using our case in point that we're talking about. Then the insured is in trouble, and Zurich is entitled to repudiate. I've then just added basically a scenario C, although there is not really one, just to say if the reasonable insured in the same position would not appreciate the possibility of a claim, there is no issue of any failure to notify. All right, so just to use the example I've recently discussed also with one of my counsel advocates, if you are a physician and you are working in a COVID ward, okay, and there's 6 patients dying on you on a daily basis, surely it would be unreasonable, and you cannot think about or expect of that particular physician to think all of those incidents or events is a notifiable event, because that is just the environment that he works in. Okay, so, and then to use probably a very stupid example, but just to, you know, bring home the point. If you are a dentist and you have 6 patients dying you on a daily basis, or, you know, you put one patient under anesthetic and he doesn't come out of it, you know, that
Stephen, mute yourself.
Hi guys, I'm getting into my thing. Can you hear me? Can you hear me now?
Yes, we can.
Okay, brilliant. Thank you. So where was I? All right, I was talking about dentists and physicians, if I remember correctly. Anyway, so yeah, so obviously, so it is all about the reasonable insured, you know, what he does for a living, and what kind of events the reasonable engineer, the reasonable architect, the reasonable attorney, whatever, is going to consider as a notifiable event or an event which could give rise to a claim. As an attorney, I've got my dates. If I do plaintiff work, got my dates when my matters will prescribe. If that thing comes out of diary late, or for whatever reason I haven't done what I was supposed to do, and that claim's prescribed, then that is a clear event that needs to be notified. Okay. If some or other client, you know, is unhappy with me, he threatens me, etc., but you know, then you obviously need to put yourselves in the shoes of the reasonable attorney. Is there potential for a claim that's going to follow? And that will depend on the facts of the matter. All right. So it is. I don't think it's that complicated. I do believe that our various professionals, it's talking about PI now, will know when an event is a potential problem in 80% or 85% of the time. It's those 15%, you know, events that is not clear, where I think they should actually go and talk to their broker. And I'll tell you just now what I think we should do from going on from there. Okay, so anyway, just to get back to our case, the court found that when Durban Cleaning was informed about the incident, it appreciated, hello, there's the word, that there was some small risk that it might result in a claim, and that Durban Cleaning would in turn refer to the insurer for an indemnity. So the court thus dismissed the claim for an indemnity against Zurich. Okay, so Zurich basically got out on top in that particular instance. All right. Okay, so just to then end off what I'm trying to say to you guys, or maybe to give some suggestions, it is, if I may humbly submit or suggest, I believe we need to advise our insured as follows. In those 20% that I've referred to of the time, or whoever, you know, especially if you are a young attorney, or if you are a young architect, you know, going on your own, etc., err on the side of caution. You know, have regular discussions with your broker. If any of those events takes place, pick up the phone and discuss it. Okay, and between the two of you, you know, if there's any uncertainty, err on the side of caution. Even if there's a small risk that may result in a claim, it should be reported. Okay. If the insured is concerned about an event, you know, if they come to you and they're worried about something, that's already a red flag for me. Report it. As broker or claims handlers, determine the issue of, and if same is or was notifiable. Okay. So as a broker or a claims handler, okay, to determine once again whether this event was notifiable, like I said, you know, look at the insurance contract, get the facts, okay. Consider the legal precedent that I've already basically highlighted to you, okay, and really, it's, if there was an appreciation, there is a claim, okay. If there was no appreciation, but the reasonable insured would have had that appreciation, okay, there's a problem for the insured. If there was no appreciation and the reasonable insured would also not have had that appreciation, then it is not a notifiable event. All right, moving towards the end. Okay, so the key question once again for determination will therefore be whether the failure to have appreciated the possibility of a claim was reasonable or not. All right, If it was unreasonable, notification was late, and the insurer may be entitled to repudiate liability. If it was not unreasonable, there was no late notification, and the insurer cannot repudiate liability. Maybe just on a personal note from my side, I do know that all of the insurers that I've worked with over the last 20 years tend to give the insured the benefit of the doubt. They do sometimes look at prejudice, even though prejudice is not really an aspect to be considered. Okay, it's a term of the contract. If the insured is in breach of that contract, they are entitled to repudiate due to late notification of that particular event. So when it comes to reasonableness or not, if it was clearly unreasonable, I think the insurer will repudiate. This is just my opinion. If there's a gray area, more often than not, I do believe that all of the clients that I have worked for to date will probably accept that claim. You know, if there is a valid sort of like quote unquote excuse, and or it's clear that there could be an argument both ways as to whether there was an appreciation of the claim giving rise, of the event giving rise to a claim or not. So, ladies and gentlemen, I said to you I was going to be brief. Hopefully that assists you with reference to the whole issue of notification. There's some other aspects that you also can talk about deriving from this with reference to, you know, perhaps things like disclosure in general, you know, and things like that. But I believe if you get this right, it really you can utilize some of these keys or whatever that I've provided you with today to also go and look at those particular aspects. You know, when there's renewals, when an insured, you know, applies for insurance for the very first time, what is the events that needs to be, you know, in the proposal form, whether there is any issues that the broker needs to be made aware of, etc. Okay, all right. So hopefully that wasn't too boring. That's it from my side, guys. So hopefully we're going to have some questions now, and let's see whether the panel and myself can address those queries. Okay, so over to you guys.
Morning, Stefan. Thank you for that interesting discussion. I just have a question for, you know, for the benefit of all our attendees. I just want to know from you whether there is an obligation on the insured to bring him or herself within the four corners of the policy by providing prima facie evidence that the suspensive conditions in the operative and insuring clauses have been met.
Marlon, if I understand you correctly, so there's an event that took place, and the question then is whether that particular event is covered by the policy or not. So, and if there's any sort of like duty to establish that particular fact, whose duty is that? And I believe, I think we may have, hopefully I have dealt with that at some stage, but you'll remember that that it is for the insured or the reinsured to prove that an event falls within the primary risk insured against. Okay, so he needs to bring it within the four corners of the policy. And then with reference to an exception, all right, it is for the insurer, i.e. an exception that limits liability. In those circumstances, the onus goes from the insured to the insurer, and then it's for the insurer, all right, to prove that that particular clause is applicable and or not. Okay, so it's proceeding to cover, it's a notifiable event, you know, so in this particular instance, I would say the onus is probably on on the insurer to convince a court that, listen, this particular event was notifiable.
Thank you.
All right.
I have another question for you.
Yeah, sure.
I would like to know whether there is a duty of, does the duty of notification rely on a claim having been made by a third party? And is the insured under an obligation to inform insurers of a possible claim, even if such claim does not materialize?
Yes, and yes, definitely. Okay, so there's definitely a duty of a notification on the insured when an event takes place which could give rise to a claim. Okay, that's, I think, one of the biggest problems I find is that insureds are under the impression that only once there's a real threat made by a third party, okay, that this particular incident, or that he's going to take him to court or whatever, you know, he needs to advise his insurers and things like that, that he needs to report the incident or the claim. That is not the test. The test is the terms as identified in the policy agreement. And like, for instance, in the case law that we dealt with, okay, there was clearly defined terms that said that if an event happens like this, I mean, this is a cleaning company and somebody falls, that's 80% of the claims that cleaning companies get, you know, as far as public liability matters is concerned. If an event like that takes place, it needs to be reported, whether that gives rise to a claim or not, okay? You'll also see that certain of the insurers, when it comes to medical malpractice matters, they, for instance, ask their doctors, irrespective, you know, if you get a letter from an attorney asking for clinical records, you report that, okay? Whether that's going to give rise to a claim or not, there's no letter of demand. They may even say, listen, we just need it for a matter that we're currently busy with. They are instructed to involve their insurer. Okay, so, you know, these things do evolve sometimes, but definitely the test is not whether there's a third party involved or not. The test is the terms of the contract. I trust that assists you in your answer.
Thank you.
Stefan, we have a question from Sekofatso. She wants to know, who is the reinsured in the context of your presentation?
Who is the reinsured in the context of, okay, so I basically refer to as the insured and or the reinsured, okay, and then obviously the insurer or the underwriter. The insured or the reinsured, that's a good question. I suppose the insured is obviously the, because more often than not, you know, to use as an example, one of my clients, there is a company, okay, let's say for instance, yes, let's use it as an instance, a mass build, okay, but the holdings company is Massmart Holdings, okay, so what happens when an incident happens is that it could affect both of these two entities. So I believe that is really what is referred to as an insured and or a reinsured. But I have to be honest with you, I did get that from LawSA. So I'll go and have a look specifically at the case law and the case that they are referring to, you know, just to get back to you.
Okay.
I don't want to lead you down the wrong path. Yeah. Okay.
Okay. Then we have another one from Andrea, who's asked, after sending a notification of a notifiable event that may lead to a claim to the insurer, when should the full details of the event be sent? As soon as possible after the event, or only after the third party approach? So I think I can come in there. Andrea,
Yes.
as soon as possible after the event. You don't necessarily have to wait for the third party approach. As soon as the information is available, when it's fresh in the mind of all the parties involved, we would like to receive the information and have it on file, so that we can refer back to it if and when there is a third party approach.
Carmen, can I also just jump in there?
Sure.
It's very important for me. I mean, it's at the end of the day, it is the insurer's decision as to, you know, steering you in the right direction as to what they want. But from an attorney's perspective, probably from a loss adjuster's as well, you know, you want to get the information as soon as possible. You want to know who the witnesses are. You want to speak to them before they start, forgetting stuff, because a year and a half later, it's very difficult to find witnesses. It's very difficult to find the people that was involved in the event. And that's, I think, to a large extent, the reason why we have this particular term in the contract is so that insurers are notified as soon as possible, so that they can make a decision, the extent to which they want to investigate this. Because if it's a huge claim for some other reason, there's a warehouse that burned down, and we're talking about a 40 million rand claim. You want to get involved, whether there was a summons as yet or not. You want to make that decision so that you are as best prepared possible to make the right decision as to whether you're going to be accepting liability or not.
Yeah, and that's why I think now it's important to reframe this. And no matter what the size of the organization, insureds need to think about putting into place risk registers, incident registers, etc., to make sure that there's a culture in the organization that each employee must update these things, and discuss with the broker, discuss with your broker, discuss each and every incident. And when in doubt, that's what we always say: notify to us. If it's not an event that is considered a circumstance, we'll tell you. And if there is a concern regarding loss ratio, I think sometimes that's what we hear a lot. There's a concern regarding the loss ratio in notifying circumstances. Rather engage with us as the insurer, engage with your broker to find out what impact it is going to have. Because sometimes you'll find the impact on your loss ratio is a much smaller risk than having your claim repudiated as a result of not notifying.
Definitely, and I think also insurers, they get to know their clients. If I may use an example, a very well-known retailer, that the specific clients that actually was responsible for starting our business, they've got, well, I can tell you, it's Woolworths. So they've got these systems in place. They call it Imbizo. I don't know what it actually even stands for, but there's a culture in all of their stores that if anything happens, you actually register it on this particular system, and that system immediately goes through to their brokers and from there or to their legal department. Now this is a big company that we're talking about, and it obviously ranges from very big to small, but there needs to be systems in place. And if those systems are in place, if you're an estate agent, or obviously runs, or if you insure a big estate agency, like whoever, Pam Golding or Remax, etc. All right, so if you do that, you need to actually, they can invest in something like that, and they need to bring it, they need to educate their staff with reference to the importance of these type of things.
Agree.
Great, thanks, Kamini. Thanks, Marlon. Stefan, thank you for a very, very interesting talk. I think, on a daily basis, especially I think in brokers' worlds, they come across, big claims with regards to maybe fires or thefts or accidents, motor vehicle claims, but not always liability claims. And I think when one does sometimes come across their desks, they get a bit of a fright. And I think this might have helped, or definitely helped in just understanding a bit more of, our world in the claims environment. Because I don't think brokers see it every day.
It's an absolute pleasure, and thank you very much for having me. And like I said, I trust that the talk was helpful. Thank you very much. It was a privilege. Thank you.
Great, thanks.